Here's what I have, counsel. I have his phone at the scene where this body is.
I'm not disputing that.
I have this woman, along with another woman, as I'm to understand it, that goes into his house. Her phone, the deceased phone, is pinged to his location. And then it's time also to understand nothing else after that. So there is certainly a whole lot that can be made up in there or assumed to be, but I got somebody that's dead. The last place I had that person is his house. That's what I got.
Judge Blanche, legal.
Good afternoon, Your Honor. Mark Krieg on behalf of Mr. Hajar.
Good afternoon, Your Honor. Ryan Murad, P83665. On behalf of Mr. Farid Hajar, who stands present to our right. Mr. Hajar, state your name for the record, sir. Farid Hajar.
All right, thank you. All right, this is the date time set for the decision on bond motion. Was there any additional information or argument from counsel?
Yes, there is some additional information.
Yes, sir.
The court was kind enough to adjourn it so that we could get a copy of the discovery, and we did get a copy of the discovery. If the court recalls, at the last hearing, I said, we don't know what the cause of death is. It could be, yes, it could be homicide, but it could be a drug overdose. If the court recalls.
I recall.
Two things that I would like to update the court on. First, I was puzzled by the medical examiner's statement that Ms. Blanche was kind enough to forward to me, where she said it's consistent with homicide, but the manner and cause of death may never be known. Those two statements, to me, can be reconciled. So I actually called the medical examiner and spoke with her. And she said to me, I'm not going to talk to you about this because I don't have anything final. And I said, well, I saw the email that you sent to Ms. Blanche. And she says, well, that was a private email. Judge, I don't think it's the business of a medical examiner to be sending private emails not to be shared with defense counsel. But Ms. Blanche understood ethically that she was required to do it, and I commend her for that. So I don't have any more information, but she certainly couldn't explain how those two statements can be reconciled. But more importantly, Your Honor, I got the discovery. And the discovery, I'd like to read to you a portion of it. It's not very long. What was not in dispute in this case, or I don't think is in dispute in this case, is that Mr. Haraj had two escorts at his house that on the evening of the 22nd, going into the early morning hours of the 23rd. And one of the escorts was a woman named Tatiana Perez, who lives in New Jersey. And the police department went to New Jersey to interview her. And I'd like to read to you what it says. Perez said they returned to Habibi's residence in Dearborn after dinner. Habibi is Mr. Haraj. Perez said there was another girl, Susan, and that's the deceased in this case. Susan, Perez said there was another girl, Susan, she knows, staying at the same hotel in Novi, and asked if Habibi wanted her to call Susan over. Habibi agreed to this and arranged an Uber to pick Susan up and to bring her to his house. Perez said when Susan arrived, the three began drinking and hanging out by Habibi's pool. Perez said they went into another room in the house, and that is when they started using cocaine. Perez said she does not use drugs and decided to leave. So what we do know, at least from the other witness that was present, is that Suzanne, the deceased, was doing cocaine, according to this, and could have overdosed, could have had a heart attack, so on.
But counsel, I mean, and I don't know if you want to make that argument, because if depending on who supplied the cocaine, but certainly it being at the location if it's that drug overdose that then results in a death, you got a whole other problem.
And I recognize that. But the evidence in this case, the discovery, there is no evidence, and I mean, burden of proof is on the people or the prosecutor. There is no evidence that those drugs were supplied by Mr. Hajar. Nothing. There was a white powder found in a backpack belonging to, who I think belonged to Suzanne, although that's not quite clear. Although the white powder did not test positive for cocaine. So I don't want to mislead the court. But the point that I'm trying to make, the burden of proof is on the government at every stage of the proceeding, although the burden of proof is lower at a.
But counsel, I don't leave behind my just common sense. I mean, I'm not sure or wise in everything in the world. Maybe somebody could tell me because I don't deal with escorts. So, I mean, I don't know if they bring their own cocaine. I would assume that that's not what happens.
But Judge, in all due respect, I mean, we're making an assumption where a man is presumed innocent, isn't even charged with this.
Counsel, this whole thing is full of assumptions. I mean,
No,
you're assuming it's a drug overdose. I don't know that.
I'm not assuming it's a drug overdose, but what I am saying to the court is the court was extremely concerned based on the evidence that Mr. Hajar may have been the one that committed if it was a homicide at all, and we don't even know that he was responsible for the death. But there's no.
Certainly that becomes a question. But to say I was overly concerned about that, here's what I have, counsel. I have his phone at the scene where this body is.
I'm not disputing that.
I have this woman, along with another woman, as I'm to understand it, that goes into his house. Her phone, the deceased phone, is pinged to his location. And then it's time also to understand nothing else after that. So there is certainly a whole lot that can be made up in there or assumed to be. But I got somebody that's dead. The last place I had that person is his house. That's what I got.
That's what you got. I'm not disputing any of that, Your Honor. And that's why when I filed this motion, I didn't ask for a personal bond. I asked for a $100,000, 10% bond because the defendant has not been charged with a murder, but recognizing that there are circumstances which might lead one to believe, although he's presumed to be innocent, that somehow he was involved in a homicide. But there's no evidence at this stage that it was a homicide. All we know is that this woman was found in a field. We can put him in that location at that time, but he hasn't been charged with the murder. And I'm not saying, Judge, and I maybe I'm just not making myself clear, but I'm not saying that it shouldn't be some kind of a cash bond, although the presumption in Michigan is to give a personal bond. But a $2 million cash or surety bond where he has to pay a bail bonds person $200,000 that is not refundable. If the court believes that a $2 million bond is appropriate, which again, in all due respect, I don't think is appropriate, then it ought to be at least a 10% bond. There's a case that the court may be familiar with, and that is People versus Reginald Davis. And in that case, the defendant was charged. Okay, I can bring the court a copy of it. May I approach the bench? This is a case where the defendant was actually charged with murder. And the judge allowed him to be released on bond. The Court of Appeals reversed it because the statute says that bond shall be denied where the proof is evident or the presumption great. It then went to the Michigan Supreme Court and the Michigan Supreme Court remanded it back saying that's inconsistent. Is that inconsistent with the court rule and with the Michigan Constitution that says may be denied? Ultimately, the Court of Appeals ruled that a defendant can be admitted to bond even where the proof is evident or the presumption great. And that's a case where he was actually charged with murder. The court does not say what the bond was in that case. But in our case, and the court said bond ought to be reasonable. That according to the court rule. So what I'm saying, Your Honor, is I'm not asking this court to release him on a personal bond. It's obvious to me, and I've been doing this long enough to read the tea leaves, that this court is not going to grant a bond that I've requested of $100,000, 10%, but a $2 million cash or surety bond where the defendant has not been charged with a homicide. It's not even clear that it was a homicide. I just think that that bond is unreasonable. So if the court made it a 10% bond, at least they could post it and maybe get some of it back at some point. But I also want one other thing. If the court will recall, if you look at all of the factors that are set forth in 6.106, one of them is a third-party custodian. I introduced the court to a former Detroit police officer who has known Mr. Hajar since they were in high school together. He said he would act as a third-party custodian. He's a retired police officer, but there's nothing in Mr. Hajar's background that would indicate outside of this offense that he has ever had any tendency towards violence. And I just think that while maybe a substantial bond, if the court feels it's appropriate, so be it. But $2 million cash or surety, I think, is excessive in violation of the Constitution. I've said my piece, Your Honor.
You would agree that reasonableness would also have to be balanced against one's means.
Correct. And if he had $200,000, he'd be out by now, Judge.
So do you want me to go through and just pull all of his financial records and anything that he's attached to in order to make a proper determination of reasonableness? I mean, that's what's going to happen. I mean, if I take your argument, that's what has to happen.
If the court was prepared, if the court wants his financial information, I'll supply it. But again, if we talked about this, Your Honor, that I said that really whether he pays a bail bondsman $200,000.
Counsel, let's be real about this. Okay. Because I think if I take the financial things, my understanding is he's tied to 11 different businesses.
He works for Kenwell Steel. That's his main business.
Whoa. But that he has interest in 12 other companies or 11 other companies.
I don't think that's accurate, Judge.
No, sir.
He has his own, he has a business on the side where he does IT work.
Come in. Also, which will make any money.
It sounds like there's only one other.
There's one other business. And at this time, it's not even showing a profit. And if the court wants to put him under oath, subject to the penalties of perjury, so be it.
I don't need to do that to set a bond, counsel. You're really making this a whole lot more complicated, I think, than it need be. But I mean, I'm willing to go there if that's what you want me to do.
Well, what I would really like, Your Honor, is if you could make it a 10% bond.
I know. That's what you would like.
That's what I would
like. And the
like.
people object.
That's right.
That is where I'm trying to balance where I land on that.
Correct.
And I can only get there by what I see in the case, what risk he would pose to leave or what risk he would pose to the community.
But he would be on a GPS tether. And if the court requires him not to live in his house and to live with Mr. Garza, he's prepared to do that. I've spoken to Mr. Garza and he said he would put him up. But again, I just keep repeating myself, Your Honor, but the point that I'm trying to make is there is no evidence at this stage that there was a homicide, that the cause and manner of death. So what you're looking at is a guideline range of either 0 to 17 or 10 to 24 at tops at this stage. If he's charged with murder down the road, then of course the court would have the option, if the proof is evident or the presumption great, to deny bond and remand him. But at this stage, for these charges, even given what you characterize as suspicious circumstances, I think a $2 million.
Quick, counsel, you need to stop with what I'm characterizing.
With a
I am just laying out what I know. That's all I'm doing. I'm not giving weight to anything at all. I'm just laying out what I know.
Right, but I think the court is concerned about the safety of the community because of the circumstances.
Anytime there's a dead body and somebody's around a dead body, yeah, darn it, I'm a little bit concerned.
Right, and understandably so. And that's why I don't expect the court to release him on some nominal bond. But $2 million, 10% is not a nominal bond. That's a substantial amount of money. And if the court wanted him to, in addition to that $200,000 10% bond, to post a house where he lives, we're prepared to do that. And then that gives some surety in addition. But I think a $200,000 cash or surety bond, they have to pay a bail bondsman this huge premium that will never be returned when he hasn't been convicted of a crime. He hasn't even been charged with a homicide. And he's only facing at this stage a charge that carries a maximum of 24 months under the guidelines. Now, I understand the guidelines are not mandatory. I know that. But, Your Honor, we live in a country where a person's presumed to be innocent. And there is no evidence in this record at this stage that this was a homicide, other than a statement that seems to be contradictory, consistent with a homicide, but I don't know whether we can ever determine the cause and manner of death. Judge, I've been beating a dead horse, which I said the other day, but again, if the court does not feel that something less than a $200,000 10% bond is appropriate, so be it. But I think that's a reasonable, fair bond under the Constitution.
Anything from the people.
Yeah, just briefly, I just want to make the record correct on the fact that the medical examiner didn't email me. I actually received the email through my officer, so she wasn't emailing me and saying, don't share this with the defense. That wasn't what happened. She shared it with my sergeant, and he sent it to me. So I just want to make the record correct on that. And he's right, this is not a homicide. That's why I'm not asking the court to deny the bond. I'm asking to set a bond. We had asked for $10 million to begin with. And under reasonableness, he's saying they can actually post this bond. They just don't like the fact they're not going to be able to get the money back. Which, if you're making that statement, then how are you saying it's unreasonable when you actually can pay for it? You just don't like the fact that you're not going to get the money back. I was quiet during your argument, sir. Can I please finish?
Sure.
Judge, when it comes to cocaine, he's relying on, he's telling the court that an independent witness had suggested that the victim had ingested cocaine that night. I don't want to try this case right now on the record. However, the defendant said there was no cocaine at the area. He doesn't partake in those drugs, and there was none there that night. So there's conflicting statements around whether or not cocaine was actually at the place. So to just blanket say that we have a witness saying that, well, the defendant said there was no cocaine there that night. And this backpack that he says belonged to the victim, she walked in with suitcases that night. The police asked the defendant for the suitcase she walked in with, and he doesn't know where they are. So I'm just concerned what's been kind of portrayed on the record.
Hold on. I want to make sure I understand that. Who is saying that she walked in with suitcases?
There's video showing her walking in with suitcases because she left the hotel, came to his house, and then the suitcases are gone.
Got it.
Judge, I don't believe the bond is unreasonable in these circumstances. I'm not asking you for the $2 million based on the fact that, this is a homicide right now. I'm asking based on the fact of defendant's misrepresentations to the police that night, the fact that we have a missing woman last seen going into his house, never coming out, and then his car going up to Northfield Township, and she's found dead in the place that his car was at. That alone, those circumstances, I believe that he presents an extreme danger to the public, and I believe based on that, you can rule $2 million for his bond. And I don't believe it's unreasonable because he's already said that he could post the $200,000, the 10% to a surety bondsman. So I don't know how you can make that argument, Judge.
I can tell you exactly how I can make that argument, because a bail bondsman requires collateral for the rest of the money. So they'd have to post collateral of $2 million. They don't have that. That's the problem. If it was just the 200,000, it may not, they could raise it, although I think it's punishment to have to do a non-refundable 200,000, but the bail bondsman requires surety such as a house. And that's $2 million because the bail bonds person needs to protect himself. No one's ever argued that he was a risk of flight. And again, this is a man who's in his 50s and has never been in trouble other than a 12-year-old drunk driving.
Counsel, what about the suitcases? What about his statement regarding the suitcases?
You mean his statement about the cocaine?
Okay. No, about the suitcases. I mean, so that's part of the problem here. Part of the problem here is that there's going to be all of these things coming out that are going to cut one way and or another. And so I was, at least for the purposes of this decision, satisfied to say there are certain misrepresentations to people that was contained in the people's motion. But now when I get down into the specifics of what those misrepresentations may be, that raises more concern for me. I mean, because counsel, the witness you're talking about, you went through a lot of things about it potentially being something involving drugs. Then we find out, and you quote a statement about the drugs, only to find out your client's denying that there was ever any drugs. Then it just gets worse. I mean, at least in terms of my analysis of what risk he poses, because now I have that woman walking in on video with suitcases. She leaves there, the suitcases aren't to be found. They ask for the suitcases, he doesn't know where they are.
There was one suitcase, it's not plural, but yes, the video
And
shows.
where's the suitcase?
Judge, I have not spoken to my.
No, but see, counsel, that's what I'm getting at. You want me to make an assessment regarding your client, the risk he poses. The more this stuff comes up, and when I ask the hard question, nobody wants to give me the answer.
I'll do my best, Your Honor. It's not unusual, at least in my experience, that people make false exculpatory statements.
I get it,
And
but they don't hide evidence. I mean, okay, that's the problem that I'm having now. Now, I come back today, and there's this other added thing now that I think I can take into account in terms of the bond.
I'm not saying that you can't take that into account. It's never been my argument that you can't take those things into account. My argument is, Judge,
Counsel, tell me what I now do with now an indication that there is potential evidence that is missing, and a statement, I think, is at least an indication from people that your client is misleading authorities as to the location of that evidence. What do I do with that?
I'd have to go back and look at the discovery because I don't want to misrepresent what the discovery. I don't recall exactly what he was questioned about the suitcase, but I know it came up in the interview. I just don't have it in front of me. But let's assume that he misled, just for argument's sake, he misled the police about that. I go back to my original point that the bond in this case, if all of that is true, then still, I think a $2 million cash or surety bond is excessive and unreasonable.
No.
All I'm asking for, Your Honor,
Counsel, it might need to be more. If I come to the assessment that not only is he misleading authorities because he has the right not to say anything.
correct.
That's one thing. But now when the statements are being made and he's misleading authorities and that it may look like certain evidence is also being secreted away someplace, that changes the whole thing.
I mean, I don't know. The evidence seems to me to be somewhat clear that they can place her in the house and place his car where the body was found. How a suitcase would add or subtract from the strength of the case, I don't see it. But I don't have any answer.
It depends on what you think happened.
The judge is already leaning forward, voice tightening as the pattern starts to click. This isn't just about bond anymore. It's about control and what's being hidden. You can feel the shift before the words land. Now it hits, misleading authorities is one thing. But if evidence is being held back or worse, quietly moved out of reach, everything changes. The tone sharpens, more direct, less patient. He starts connecting it out loud, statements that don't line up, missing items, unanswered questions. And suddenly the argument about reasonableness collapses under the weight of something bigger. Because now it's not just about what the defendant did, it's about what he might be trying to keep from being found. And that changes the entire equation.
Again, Your Honor.
And then it would also depend, and it may not add or subtract anything from the case. But then you have to ask the question, if I have an individual that then is not, I don't know that defendants necessarily have to cooperate with authorities, but that is then not turning over evidence.
There was a
Counsel, that puts you into a whole other place. And you know that.
They did a search warrant on the house. They executed a search warrant.
No, but counsel, they know that something exists. They ask your client. They have proof that something existed when it went into that house.
That's correct.
They ask your client about it. Your client says that it's not there, whatever he said. You know that puts any argument that's being made from any court's perspective in terms of reasonableness of the bond, that puts it in a whole different light.
Judge, I made my.
That's what I'm saying. It's getting worse.
Your Honor,
And
again, I don't want to just keep repeating myself. I'm not asking for a nominal bond. $200,000 is a lot of money. A lot of money for someone that's not charged with a homicide and is presumed innocent under our Constitution. Again, I'm not even, $1 million would be a sizable bond for someone with as it sits today, where there's no evidence that it was a homicide, that they haven't found the cause of death to be a homicide or the manner of death to be a homicide. And it would seem to me that.
But you have to factor into that. I also have somebody that it is also alleged as lying to authorities, who also is having evidence that they're not turning over to the police and or have secreted in some way and or destroyed. It doesn't go one way, counsel.
I'm not saying it does go one way. All I'm saying, Your Honor, is $200,000 is a substantial bond. If it's 10%, that's all I'm saying. I'm not asking the court to release him on a personal bond. Although it was my original request to do $100,000 10% bond, but he's not charged with murder at this point, and they haven't even shown that it's a homicide at this point. And it may be quite some time before that happens, and he sits in jail on a case that has, at worst, 10 to 24 month guidelines. That's my argument, Judge, and I don't mean to keep repeating myself. I'm just asking that the court reduce it at this point to a 10% bond.
Anything else in the people?
No.
Court's gonna stay in recess. Everybody can remain seated. Back on the record, case of the People versus Hosier. Counsel is present. The court has reviewed the Court of Appeals case and read over the Court of Appeals cases provided by the defense. Let me first say, as I said at the end of the last hearing, I do not believe that the bond as set by the magistrate, at least based upon the information that the court had at the time, that this court had at the time, that this court could constitute or say that that was an abuse of discretion. What is notable in the defense's argument, and all of it certainly being legally correct, but then again, taking those arguments and applying them to particular factual circumstances, at least as the court would know them at this time, may be where there is some difference. Notable is the defense's statement that the $200,000 that may be required to pay a bondsman, that could be accomplished, but that then there is that the real crux of the issue is that should everything go forth through trial, through everything, where there would then be a release of that surety, that the defendant does not get that back, or the monetary funds back. That is correct, but they're also not having to put up the entirety of the $2 million. But what's notable in that is that the $200,000 could be indeed posted. The more the facts are laid out before this court, the more the court has not just questions, but certainly has concerns about safety to the public. I don't doubt that there are individuals had basically a full courtroom the last hearing, that there would be individuals who would vouch and that the defendant could be released to. That isn't really the court's concern. What is of concern to the court is that as this is ongoing, the risk, the danger, as it is uncovered as to maybe what occurred in this case, would lead the court maybe to a different conclusion as to the defendant's danger to the community and the threat that he may pose. By way of example, certain facts today, some of them laid out in generalities, but not in specifics, were not known to the court just last week. And they do give this court great pause. And I don't think it unreasonable for this court to take into account what may be statements made for the purpose of misleading.
The courtroom settles, but the tension doesn't. You can hear it in the judge's delivery, measured but firm. He's already made up his mind before the key line lands. He acknowledges the argument, even concedes parts of it. But then the reality comes back in what's been uncovered, what still doesn't add up. Each detail stacking, quietly reinforcing the risk. And then the shift, almost subtle but decisive. The bond stays, $2 million, not lowered, not softened. In fact, he goes further. What came out today, it could have justified going even higher. That lands hard, because now the message is clear. This isn't just caution, it's concern. And until those questions are answered, nothing about this situation is getting easier for the defense.
An investigation and/or the concealment or the destruction of potential evidence in the case. One of the reasons why I wanted is counsel were going through everything last week, that the defense at least be presented with or have the discovery in case those arguments were made. That having been said, the court is going to rule in this case that the bond is set by the magistrate. As I've indicated, I don't believe is unreasonable. I do not believe, under the circumstances, I do not believe that it is unreasonable. I do not believe that it was an abuse of discretion in terms of the magistrate in setting the bond. To be quite frank with you, given what I learned today, it might lead this court to think that a higher bond might be required. But I'm not going to do that either. I'm going to leave the bond where it is at $2 million, cash or surety, so that it can be posted. I will do this, however. Should the defendant not be able to post that bond, I would give the defense an opportunity to produce to the court certain financials, which I think the court, certainly under the court rule and otherwise, can take into account in terms of his ability not necessarily to pay the $200,000 to the bondsman, because it's already been acknowledged by defense that they can do that. The question is the collateral that would frame up the $2 million. And the court would take a look at that and then reevaluate if bond cannot be posted. The court would then reevaluate and take a look at the bond. I would also say, however, because of at least what the court knows or thinks it knows at this point in time, that as a additional condition of the defendant's bond, and I believe that the magistrate did order a GPS tether, I would order that if the defendant is released, he is to be a GPS tether is to be placed on the defendant prior to his release. Indicated also he would have to surrender any passport or any other documentation which would permit him to travel outside of the United States. Additionally, as part of this court's order, given what I've seen here, that should there be enough evidence at some point, and this will be a condition of his bond, that if there be enough evidence that the people would file and charge the defendant with open murder, first or second degree murder, or any other type of homicide type of an offense, that the defendant bond as set would be canceled, and he would then have to surrender himself immediately to the Washtenaw County Jail if those charges were to come about. And that would, as indicated, be a condition of his bond in this case. That is the ruling of this court. Is there any questions regarding the court's ruling?
I do have a question, Your Honor. Well, I have two questions. One is a comment, not a question. I had proposed to the court that in addition to if the court would impose a 10% bond, that in addition, we would post a house, which would be similar to what a bail bonds would require. I'm not sure how much equity there is in the house, so the court would consider that. And I think there's a relative that would also post a house in addition to his own. So I would ask that the court consider that. The second question I have, the next comment I have is the passport is already in the possession of law enforcement. It was in a safe that was taken at the time, and that is in the discovery that they have possession of his passport. The question I have, if somehow at some point he does get released, can he work? I know he has to have a GPS tether, but I would like him to his employers, I gave a letter to the court last week, said they would take him back.
But would he leave the state of Michigan?
No, he would not leave the state of Michigan.
Originally, a home confinement was ordered, so I don't know if that was now unreasonable deemed by the court, but that was originally, the home confinement was ordered on his bond.
Without much else, I don't know that I'd order a home confinement. I would just order a GPS tether with location tracking at this point.
Would the court consider if we can post 2 residences that equal, let's say?
Counsel, I think I was very direct in my.
Okay.
That is.
I'm going to shut up, Judge.
If the bond as set cannot be posted, I'm giving the defense an opportunity to provide to the court financials that would lead the court in a different direction or to restructure his bond.
Thank you.
So with those conditions, defendant's motion is denied regarding a reduction or change in bond. I've given the opportunity for you to do other things and provide that to the court. I will look at it. I will diligently look at it. And if there's something that can be fashioned, I will do so.
I appreciate it, Judge.
All right.
May I have a word with the client and my co-counsel regarding the next probable cause conference?
Sure.
Okay.
The people will prepare their order for the court signature. Yes. That microphone, you might want to hit that so that it's not picking up. They're very sensitive. So it needs to be green. It should be green if it's.
And I appreciate the court's patience. It's been the longest bond hearing I've heard.
Yes, and after 25 years sitting here, my longest one ever. So.
Your Honor, we would ask the probable cause conference to be put over 1 week so that we can see whether he has the wherewithal to post a bond under this current conditions or whether we need to present financial information. So that would be, let me just make sure I have that date open.
August 1st.
Pardon?
That would be August 1st.
August. Can I just check my calendar, Judge? That looks good. Do you want to do it at 3 o'clock again?
No, my PCCs are so, here's what would happen. My PCCs are set in the morning. If you were to file something or wanted something heard, it gets switched to this 3 o'clock time.
Okay, fair.
So
Okay,
I said everything at 9. You will get a invite from the court, which puts you into one of the hour blocks throughout the day so that you're not here all day waiting.
okay, and then
You're
if,
set in the 9 o'clock block, because the in custody block, which currently he would be set in, is a 3-hour block, but
great. May I approach the bench with the prosecutor for a moment?